Thank you for joining the Oklahoma Land Title Association for the 2019 Legislative and Case Law Update. This class has been approved by the Oklahoma Department of Insurance for 1 hour of legislative update continuing education credit. My name is Monica Whitrock, and I am a National Director for Corporate Underwriting for First American Title Insurance Company, but Oklahoma is my home, and I've been a proud member of the Oklahoma Land Title Association for more than 20 years. I'm pleased that you've joined me for the next hour in this review of the new Oklahoma statutes, Oklahoma Supreme Court cases, and title examination standards affecting our industry that were affected last year. If you have any questions or comments about any matter covered here, you may contact me at mwhitrock@firstam.com. Let's start with the new statutes that were passed by the Oklahoma legislature in this past 2019 regular session. Starting with Title 59, the Real Estate Licensing Code. It was amended last year. The amendment addresses inducements under the Oklahoma Real Estate License Code. The prohibition is for using prizes, money, gifts, or other valuable consideration as an inducement to secure customers or clients to purchase specific property. However, real estate licensees may use prizes, money, gifts, or other valuable consideration for marketing purposes, provided that they are not contingent or limited to individuals making an offer or purchasing a specific property. So what does that mean for our realtors? For years, our customers have wondered if it was okay to give away a branded bottle of water at an open house or put out cookies or other snacks. What about giving away a $25 gift certificate and a drawing for people who have recently liked your Facebook page? Prior to this new law, the answer was no, because the law did not allow real estate licensees to provide any prices or other item of value to influence a purchaser or prospective purchaser of real estate. The new law still maintains that inducing buyers is illegal, but the statute clearly outlines that giveaways for marketing purposes are permitted as long as receiving the item is not contingent on individuals making an offer or purchasing a specific property. As an example, providing a chance at a $25 gift certificate for making an appointment to view a specific house listed by the realtor is still improper. But offering a chance to win a $25 gift certificate for liking a Facebook page is okay. Specific inducements targeted at specific property is not allowed. But general marketing to increase a realtor's recognition in the marketplace is okay. One of the biggest frustration in our industry is dealing with the lack of spousal signature on a deed. So we have an amendment to Title 16. While Title 16 still protects the legacy of a spousal interest in homestead property, an amendment to Section 13 passed last year now provides a solution for non-homestead property. This amendment provides that there is a recorded conveyance of non-homestead property that has been executed by a married grantor without being joined by the spouse. It will be considered valid if, 1, an affidavit is signed by the non-joining spouse stating that the property was non-homestead property, or 2, a subsequent conveyance is executed by the non-joining spouse, with or without others, relinquishing any claim to an interest in the property and stating that the property is non-homestead property in favor of the same grantee or to a subsequent grantee. Boom. Title, curative, problem solved, right? The next amendment involves Title 28. Recording fees were increased last year, with this amendment adding an additional $5 per document for modernization and archival fee. Here's hoping, especially in light of the courthouse restrictions this year, this additional revenue will move more of our county clerks towards the acceptance of electronic recording. The Oklahoma Remote Online Notary Act went into effect, supported by the administrative rules implemented by the Secretary of State on January 1, 2020. Many title companies around the state are moving into this electronic closing experience. And it's really been interesting to see how this has rolled out here in Oklahoma and around the country. Oklahoma was really ahead of most states in the enactment of this legislation, and you have your Oklahoma Land Title Association to thank for that. Let's break the new law down a little and take a deeper dive into the laws to see really what's going on here. So let's take a virtual plunge together. There's three major core components of the law. One, a robust multi-step identification process that includes knowledge-based authentication and ID verification during the signing session. Number two, the audio-visual recording requirement. And three, requirement of disclosure that it was a webcam notary that was used for that particular transaction. So let's talk a little bit about the remote online notary, just at a very high level. A separate application must be made to the Secretary of State to be commissioned as a remote online notary. The notary must use approved secure technology that needs to be identified at the time of the application. The notary must notify their witness or the principal by one, notary's personal knowledge of the principal or affirmation of credible witness who personally knows the principal. And that's present in our current law right now. That's nothing new. But what's added is the multi-factor authentication. That involves three components. One, identity proofing of the principal, which is knowledge-based authentication. It's called KBA. Those are questions that the witness must answer that would be related to information that only the witness knows. Two, a remote presentation of the government-issued ID with the picture during the signing session. And three, a credential analysis of that identification. The notary must be located in Oklahoma, and the notary must certify that the paper copy is a legitimate copy once that information is printed out. If there's any kind of acknowledgement, there must be a notarial certificate that must disclose the remote online notary was used. The remote online notary may charge $25 for that service. And then the RON must maintain a journal and retain audio-visual recordings for 10 years. They can use a third-party depository. So many of the companies that are providing these third-party providers for all of this technology can also work with your company to maintain that journal and the audio-visual recording as well. And the Secretary of State has adopted standards. They did that late last year. And there's your site in case you have any questions. I thought you might be interested in seeing what an acknowledgement looks like. Just merely says, this record was acknowledged before me by means of communication technology. There are other forms, including jurats, witness attestations, what your acknowledgement would look like in the event you had an attorney in fact or corporation or trust. Those are all found in Appendix A of the rules of the Secretary of State. Once the document is papered out, there's a certificate of authenticity that would be required to be executed by the notary. And you can see here as an example, it merely says, I certify that the preceding or attached document, you identify the document and the date and the number of pages, is a true and correct copy of an electronic document printed by me and under my supervision, and that at the time of printing, no security features present on the electronic document indicated any changes or errors in an electronic signature or other information in the electronic document since its creation or execution. The notary is charged with this responsibility to make sure that there are no changes to those documents in the electronic form to the paper form. There's a few other statutes that I think are really important to understand and have a complete picture of what the Oklahoma Remote Online Notary Act is and how it interfaces with other laws. It's important to know about the Electronic Signatures and Notarization Act. We call that UETA. That's Uniform Electronic Transfers Act. That act has been around here in Oklahoma since 2001. A traditional Oklahoma notary can perform an electronic notarization, affixing an electronic signature and seal to an electronic document. But both the notary and the principal have to be physically together during the notarization. And the important thing to know about this law is that UETA does not apply to laws governing the creation and execution of wills, codicils, and testamentary trusts. So that's a challenge for our estate planning friends. And it does not apply to UCC Article 2(a), which in our world really affects those promissory notes. So when we're dealing with something in our industry in terms of electronic closing, while we may be able to execute all other documents by electronic signatures, we cannot do that with the promissory note. The promissory note requires a wet signature, except for a new law that we'll talk about here in just a moment. Now, remote online notarization is what we've been talking about. A remote online notary has authority to perform the notarization via audio-video feed. The notary must register with Secretary of State, must certify that the notary intends to comply with technology standards for third-party software providers. So what that new law obviously means is that the notary and the witness can be in two separate locations. Recordation of electronic documents in tangible form. Title 16 establishes the ability of our county clerks to accept electronic recordings. And that law has been around probably since about 2006 or 2007. And then the last statute for you to pay attention to is the Electronic Signatures and Global and National Commerce Act. We call that the federal e-sign. And this is the law that establishes special technology and business process standards for electronic notes secured by real estate. So if we have a lender who has complied with the statute, they do have electronic notes, they have what's called an e-vault for their loan, then we can help them with a complete electronic closing experience. So I hope that gives a little bit of structure around the whole remote online e-closing, but watch for other materials to come your way from the Oklahoma Land Title Association. All right, let's move on to Title 17. This amendment provides for new setback lines for wind farms that are located near airports and military facilities. And it also provides for approval by the FAA and U.S. Department of Defense. So this would be important for our abstractors and OLTA members that may be handling transactions near one of our Air Force bases or other military facilities. We have a new law dealing with judicial record of death that was effective last year. That new law provides a judicial process for obtaining a judicial record of death in cases where a death certificate is required to settle a property or financial interest of a person who has died 25 years ago or longer, and there is no death certificate on file with the state registrar of vital statistics. This law was really pursued by our friends in the oil and gas industry, but it obviously will help us when we're dealing with curative matters. So that's really it for all of the new statutes. We have a few new title standards. Every month, the Title Examination Standards Committee of the Oklahoma Bar Association meets to discuss new standards or standards that need to be updated or amended based upon changes in the law or decisions of the courts. This year, there were just a few that I want to highlight. The first one has to do with Title Examination Standard 23.11 involving foreign money judgments. This is a new standard. And if you'll remember, a few years ago, we had a case called TerraCore versus Daly, and Automotive Finance Corporation versus Rogers that applied to foreign money judgments. So I won't read that for you there, but just know that there is a new standard to allow a little bit better guidance when we're dealing with a foreign money judgment that is filed in our own state. The next one to discuss is Title Examination Standard 17.4. And really, this is just a little bit of a clarification having to do with transfer on death deeds involving a surviving spouse. The next one is Title Examination Standard 17.4, and it's just an additional comment that was added to give a little bit better guidance with respect to the timing of, to the revocation of a transfer on death deed. The next is a pretty good look and some changes to our title examination standards on series LLCs. A couple of years ago, the committee really worked hard to put together a set of standards. And this year, they just refined some of those to give a better picture of when we need to start paying attention to the way a series LLC can hold title to real property. And that's just a continuation of the same. And it goes on. You can just see, I won't go into a lot of detail, but it really is nice to see all of this and appreciate the work all of the committee did to put into giving us some good guidance with respect to series LLCs. The next one is Title Examination Standard 14.10, 7.2, that deals with marital interest in marketable title. And this was just a little bit of a change to go along with the new statute that I just talked about a few minutes ago, having to do with the affidavit executed by the non-joining spouse. Title Examination Standard 34.2 went into a complete overhaul. So just want you to be aware that there's been a lot of changes. A lot of references have been changed. A lot of time limits have been changed, such to comply with all of the changes in the bankruptcy code over the last several years. And that does it for us for the title examination standards. Now, the last segment of our time together will be used to discuss a few of the court cases of interest to the real estate community that were released for publication last year. The first case is the estate of Walker. The estate of Walker involved a gentleman by the name of Clifton Walker, who died in 2011, and he was a resident of Mays County. His wife, Beverly, was the sole heir. The attorney filed the probate case in Osage County, right? He lived in Mays County, but the attorney filed the case in Osage County, and the attorney was appointed the personal representative. The probate was completed, uncontested, no appeal, no problem. But in 2017, the attorney filed a probate case in Mays County. Well, the wife, Beverly, objected, asserting that Mays County didn't have jurisdiction because the probate had already been completed in Osage County. The attorney's response was that Osage County lacked jurisdiction in the earlier probate. Well, the trial court denied Beverly's objection and she appealed. The Court of Appeals reviewed the motion to dismiss de novo. In the original version of the statute covering the venue of a probate, there was a stated order of priority. The statute was later changed to remove that order of priority, and the Court of Appeals held that under Title 58, Section 5, there is no priority now under the law as to the county in which a probate case must be filed. A probate action may be filed in any of the applicable situations listed, and in this particular case, that was where application for letters testamentary was first made, which was in Osage County. Now, just a side note, there is a bill pending currently in the legislature. It's House Bill 2916 to add the priority, the order of priority about where a probate must be filed, and adding that back into the statute. The next case is Herring versus Graham, which is a really good reminder about foreign judgments. This is a case out of Harper County where the trial court ruled that a Kansas judgment filed in the county was facially void for lack of jurisdiction. The Kansas judgment was basically an elder abuse case, resulting in the rescission of deeds covering property in Kansas and also in Alfalfa County in favor of the estate of Jones. That Kansas judgment was filed in Harper County. The trial court found that the judgment was void on its face because the judgment with respect to the Oklahoma property was in rem, in other words, adjudicating title to Oklahoma property. Well, the deal is that the judgment rendered in the Kansas court was just not very clear whether it was in rem or in personam. Whether it was in personam or in rem was really for the court to decide. So the Court of Appeals reversed the case and sent it back to the trial court to conduct a full hearing. So again, just a reminder that a foreign court cannot directly affect title to Oklahoma land in rem. It can only indirectly affect the person's holding title. The next case is Wells Fargo versus Lamb. In this mortgage foreclosure case, the plaintiff joined the Oklahoma Tax Commission as a defendant because there was a recorded tax lien against a person named Fong Lam. Defendant in the foreclosure action was A. Fong Lam. The Oklahoma Tax Commission filed an answer asserting its lien and asking judgment in its favor accordingly. Mr. Lam filed an answer in the foreclosure case alleging that he was not the same person named in the tax lien. He provided his social security number and other identifying information to show that it was not him. Lamb's attorney also notified the Oklahoma Tax Commission outside of the foreclosure action and requested that the Oklahoma Tax Commission withdraw its answer. Tax Commission didn't respond. 4 months later, Lamb's attorney sends another request to the Oklahoma Tax Commission to withdraw his answer, and this time he says that if they don't, he's going to file for sanctions in 21 days if the Tax Commission did not withdraw its answer. Well, the Oklahoma Tax Commission sends an email back to the foreclosure attorney and basically says they have no way of knowing whether this taxpayer named in their lien was the same person as the defendant in the foreclosure action, and asks the foreclosure attorney to dismiss the Tax Commission from the case. Well, the Tax Commission never withdrew its answer. Lamb ended up filing a motion for sanctions and attorney's fees. Well, then the Tax Commission finally withdrew its answer. The trial court basically said, too late, you should have taken care of the problem earlier, and Mr. Lamb has been damaged as a consequence. So, Tax Commission, you get to pay it. Hodge versus Wright is next. This was a quiet title action by Yvonne Hodge against a bunch of defendants. The trial court denied her remedy because she could not prove ouster of her co-tenants, and her only remedy would be partition. The Court of Appeals, in reviewing the evidence, found that Hodge had purchased the property from an estate in 1993. Basically, that chain of title was a mess, and Hodge filed a quiet title action to clean up the title. She names all of these defendants in the action, and some of them actually came forward to claim that they had inherited interest in the property with roots going back as far as 1935. Well, since 1992, the Hodges had paid taxes, made improvements, built fences and ponds. They ran cattle, they cleared trees. They basically dealt with the property as their own, thinking that they were the rightful owners of the property. And the Court of Appeals notes that no other person ever came forward to claim or assert any right to the property until the Hodges filed, or Mrs. Hodge filed her quiet title action. The court held that in an adverse possession action against a co-tenant, the same elements must be proved as in adverse possession cases against a third party. An actual ouster is not required. So Ms. Hodges won the case. The next case involves a set of facts that many of us in our association are familiar with. Texas File is a company that provides remote access to images of county land records to its subscribers over the internet. Texas File already had contracts with county clerks in Blaine, Logan, Oklahoma, and Grady counties to receive digital land records for its business. In 2016, Texas File made a request pursuant to the Oklahoma Open Records Act for a complete electronic copy of all of the Kingfisher County land records that were currently available in electronic format. Well, the Kingfisher County clerk denied the request because the Oklahoma Open Records Act did not apply, and she also cited the Armstrong case from 2012, prohibiting the commercial use or dissemination of records for resale. Texas File filed a declaratory judgment and mandamus action against the county clerk. The question presented was simple. Are the county clerks required to comply with Texas File's requests for land record information so that Texas File can sell the same for a profit? The trial court agreed with the county clerk, and the Court of Appeals agreed with the trial court, holding that the Open Records Act and the Abstractors Act both prohibit the provision of electronic copies of county land records or document images when they are intended to be resold for commercial. The next case is Riverbend Land versus Oklahoma Turnpike Authority. Every abstractor really needs to read this case. This is a quiet title action that was decided by the trial court in favor of the Oklahoma Turnpike Authority. Riverbend appealed. The chain of title reveals that Riverbend's predecessor in title conveyed property to the Oklahoma Turnpike Authority to a legally described tract of land, which happens to be near Rockwell and Memorial in northwest Oklahoma City. But the grant goes on to say that the grantors also conveyed the property together with all abutters' rights, including access from the remaining portion of the grantor's land onto the limited access turnpike to be constructed on the described land. Well, the remaining portion of grantor's land was never described in the deed. Consequently, the remaining portion of grantor's land couldn't be indexed by the county clerk. Those abutters' rights couldn't be indexed. In short, the Court of Appeals found that the lack of description did not give constructive notice to a third-party purchaser, in this case Riverbend, and is thus outside the chain of title, and the case was reversed and remanded back to the trial court. CIT Bank of Heirs versus Heirs of McGee is a pretty simple case. That's our next one, that reinforces the notion that although there may be unpaid homeowners association dues, they do not become a lien on the land and perfected until an actual notice of the lien is filed. Thus, a mortgage lien recorded before the homeowners association lien is clearly superior to the later filed homeowners association lien. The last case is the estate of Stolba, and I love this case. Mrs. Stolba, her will was admitted to probate in 2012, and it appears that she composed her will without any legal assistance. It appears that she was attempting to create a trust to hold the property for the benefit of her family. While the probate was still open, which was about 5 years, one of the sons filed an application to distribute this homestead property because the trust was not properly established. He argued that the trust provision was so lacking in any substance that it was impossible to determine the intent of the trustor. There were no duties established for the trustee. There was an absolute prohibition on the alienation, and neither the trust nor the will provided for any final disposition of the property. So let's look at the actual language that Mrs. Stolpa crafted into her will. She says, the homestead will remain in trust, not to be sold or split. All four of you have got to get along. Work it out. You should be able to have fun doing things there. Everyone should behave themselves. Well, within this very simple testamentary disposition, there were 8 fairly complicated issues on appeal. The bottom line is that the trial court found that the trust failed for lack of dispositive intent and the provision covering the homestead was invalid. The court distributed the property as partial intestacy. They did not uphold the trust, and the Court of Appeals agreed and confirmed. So I just have one other thing to share with you. There were a few changes to the real estate purchase contracts from the Oklahoma Real Estate Commission, but none of them really affect our relationship and our responsibilities to parties to a transaction. So I don't have really anything new to share there. But I do want to make sure that everybody's paying attention to the COVID-19 emergency orders. This is very important here just because in this particular emergency order issued by the Supreme Court and the Criminal Court of Appeals, it says, in any civil case, the statute of limitations shall be extended through May 15th, 2020. So the important part of that for our industry is just to make sure that you don't eliminate any requirements or any other curative items based upon the extinguishment of that right by a statute of limitations, such as, for example, a foreclosure action on a mechanic's lien, or maybe some other kind of civil action that would take place on something that you might see in the record title. So, and make sure that you stay close to your underwriters on this issue. The information I'm giving you is as of May 1, 2020, but make sure that you check oscn.net for current emergency orders or an extension of any existing emergency orders. And with that said, I just want to thank you for spending the last hour with us here at Oklahoma Land Title Association. I hope this has been helpful. And please, if you have any questions, please don't hesitate to reach out to me or contact April Jolly, and she'll be glad to help you. Thanks, and enjoy your day.